On the 20th of May 2013, a contractor for the US National Security Agency flew from where he worked in Hawaii to Hong Kong. Days later, he met two leading investigative journalists in a hotel lobby, and between them, they worked to publish information about secret government spying programs which changed forever how we view state power and surveillance. That contractor was, of course, Edward Snowden, and 10 years ago he blew the whistle after witnessing firsthand the vast amassing of our private lives that intelligence agencies around the world were secretly undertaking. You're about to hear from privacy campaigners and parliamentarians who, after the Snowden leaks, took action. Faced with an unrepentant government who are more concerned with attempting to silence the journalists who published Snowden's materials than coming clean with the public and reining in the intelligence agencies, it was clear that these surveillance powers would have to be challenged in court. So that is what they did.
My name is Caroline Lucas. I'm the Green Party Member of Parliament representing Brighton Pavilion since 2010. After Edward Snowden blew the whistle on illegal mass surveillance practices in 2013, it was clear that everyone's private communications were at risk of unwarranted state spying. That includes sensitive private communications between MPs and the public, who we have a duty to represent. And I was concerned that if members of the public can't speak to us without those communications being scooped up in the government's mass spying, then not only is our privacy and freedom of expression at risk, but democracy can't flourish. Blanket surveillance of politicians is nothing short of a stain on parliamentary democracy. So with my Green Party colleague, Baroness Jenny Jones, we began a legal challenge against the UK security services to protect the privacy of communications between parliamentarians and the public. The Wilson Doctrine is an important principle, decades old, and it's basically called that because in 1966, the then Prime Minister Harold Wilson assured Parliament that parliamentarians' phones and mail must not be intercepted by the authorities except in exceptional circumstances with prior authorisation from the Home Secretary. Now, our case was heard in the Investigatory Powers Tribunal, and whilst the tribunal acknowledged that the Wilson Doctrine would apply to targeted interception of parliamentarians' communication, it said that that didn't apply to mass spying. Now, that was not the outcome we hoped for. The judgment was frankly a body blow for parliamentary democracy. Parliamentarians must be a trusted source for whistleblowers, from campaigners whose groups have been infiltrated by the police to those exposing corruption in government departments. And constituents have a right to know that their communications with me aren't subject to blanket surveillance. It strikes at the heart of our democracy. Our job is to hold the executive to account, and how effectively we can do that is undermined if our communications are being monitored by the state. However, our legal challenge illuminated the problem of state spying on politicians, and we used the momentum to campaign for better protections in the new surveillance law, the Investigatory Powers Act. Under that Act, the Prime Minister must personally approve a targeted warrant for an MP. It doesn't address our concerns about bulk spying, though, and so we must continue to defend privacy and democracy, particularly as new technologies advance. But MPs wouldn't have known that our constituents' private communications were being affected by mass surveillance without Edward Snowden's whistleblowing. His actions have helped to inform our democracy and enabled me to bring this important legal challenge.
I'm David Davis, MP. I'm one of the people who have been involved in civil liberties, privacy, use of data, surveillance for the last 20 odd years, certainly bracketing the time that Edward Snowden shocked the world, really, with his revelations about what the American and British and other security services were doing in terms of monitoring our everyday lives. One of the disturbing things that happened after the Snowden revelations was that the mass surveillance practices that he exposed, which had a highly questionable legal basis, started to be put on a new legal footing by Parliament. A temporary law allowing the UK authorities to continue collecting mass communications data, called DRIPA, the Data Retention Investigatory Powers Act, was passed in July 2014, a year after the Snowden revelations.
Mr. David Davis.
The government rammed this law through Parliament in a single day, without any time for proper scrutiny or debate. The authorities do need to be able to access so-called metadata where it's necessary to investigate serious crimes. But such intrusive access to anyone's data should be authorised by a judge. All other Five Eyes nations use judicial involvement in surveillance warrants. but the new law forced communications companies to store detailed information about the locations of everyone's mobile phones, as well as the who, when, how of every email, text, phone, call and internet communications, including those of lawyers, doctors, journalists and MPs like me, and without requiring a judge's approval. And so a week after this law was passed, I started a human rights legal challenge, along with Tom Watson, a former Labour MP, to protect the Article 8 right to privacy in Britain. We argued that DRIPA contained inadequate protections for British people's fundamental rights, letting hundreds of organisations and government agencies, from police forces to the tax office, grant themselves access to this highly personal and revealing data for a huge range of reasons that had nothing to do with investigating serious crime. The High Court agreed with us in 2015. This was an historic moment. It was the first time a Member of Parliament had brought a successful judicial review against the government. The government appealed, and the Court of Appeal referred the case to the European Court of Justice. In December 2016, the European Court echoed the High Court's ruling and went further, setting down safeguards that the government needed to introduce to protect people's privacy. It's regarded as one of the most impactful legal judgments on privacy post-Snowden. The court agreed with us that the law cannot be considered to be justified within a democratic society, and that such mass surveillance would cause the public, quotes, to feel that their private lives are the subject of constant surveillance, unquote, affecting our rights to privacy and to freedom of expression. A month before the judgment, the government overhauled the UK's mass surveillance law, and passed the Extraordinary Investigatory Powers Act, which introduced the most expansive surveillance regime of any democracy in history. Our judgment meant that changes immediately had to be made to that act, including that metadata should only be accessed in relation to serious crime. However, the government weakened the definition of serious crime. As my legal challenge shows, the work of protecting liberty is never done. But thanks to the Snowden revelations, British democracy is better informed about the unprecedented surveillance powers the state had secretly accumulated, and I was able to take this important action to defend British liberty.
Big Brother Watch was founded in 2009 to roll back the ever-expanding surveillance state. So just a few years later, when Edward Snowden bravely revealed the extent of mass surveillance in the UK, we took action. Snowden revealed, amongst many other spying programmes, one of GCHQ's most powerful surveillance tools, Tempora, a mass data collection programme that captures data directly from the underwater fibre optic cables, texts, calls, emails, internet history, social media posts and more from across the world. These tapped cables have the capacity to deliver more than 21 petabytes a day, equivalent to sending all of the information in all the books in the British Library 192 times every 24 hours. This virtually unfettered access to our communications made a mockery of privacy rights, and so Big Brother Watch, along with other privacy groups, took our case all the way to the European Court of Human Rights, where we argued that the UK government's bulk interception of communications data had violated all of our right to privacy. This was the first case concerning mass surveillance that the court had heard since Snowden's revelations. The UK government was forced to admit that the purpose of bulk surveillance is not to search for the communications of identified targets, but to gather mass data and decide who should be a target. This approach subverts the democratic principle that suspicion should precede surveillance. Instead, it treats us all as suspects. The court found that this bulk interception regime had a number of fundamental flaws and therefore unlawfully violated citizens' right to privacy. The threadbare safeguards the government had put in law were not sufficient and allowed agencies too much discretion. Disappointingly, though, the court failed to challenge the core presumption that mass collection of our communications data is necessary or proportionate, instead taking the government at their word that this is the solution to terrorism and serious crime, despite a lack of evidence. This meant that while our legal challenge secured important new safeguards, the UK's bulk interception programme could continue. The judgment was not unanimous, however. A dissenting judgment from Judge de Pinto de Albuquerque was highly critical of the court's findings and gave a stark warning about the future. The government's case boils down to a simple proposition, which is trust us, he said. The majority were ready to accept this proposition with the risk of erring on the side of over-collecting intelligence. I am not. Admitting a non-targeted bulk interception involves a fundamental change in how we view crime prevention and investigation of intelligence gathering in Europe, from targeting a suspect who can be identified to treating everyone as potential suspects whose data must be stored, analysed and profiled.
Hi, I'm Caroline Wilson-Palo, Legal Director at Privacy International. We're one of several organizations who brought legal challenges against government surveillance practices revealed by Edward Snowden. I'm going to tell you about two of those challenges, both of which tackled very intrusive forms of surveillance. The first, which was described quite clearly in the Snowden documents, was the UK government's ability to hack any of our devices. That is, to remotely and secretly access our phones, computers, smart fridges, or pretty much anything else that's connected to the internet. This could allow UK intelligence agencies to access private details about any of us, from our intimate messages to location history and even thoughts we typed out but never meant for anyone else to see. They could also remotely turn on our devices' microphones and cameras, turning them into secret recording devices. We filed a lawsuit against the UK intelligence agencies because in 2013, when this hacking capability was revealed, there was no clear legal framework governing its use, much less sufficient safeguards to protect us all from its strong potential for harm and abuse. And we've since seen other countries abuse similar technology, like spyware, to hack journalists, opposition politicians, human rights defenders, and many others. Our UK case took us in interesting directions. After we filed the lawsuit, the UK quickly rolled out a code of practice to govern its hacking powers. This was enough to convince the tribunal before, the IPT, which hears claims against the UK intelligence agencies, that the UK was acting within the law. But we disagreed, so we tried to have the ordinary courts review the IPT's decision through a process called judicial review. We ended up at the UK Supreme Court on the question of whether the IPT could be judicially reviewed, and we won. We then went back to the High Court, which found the IPT did get certain points of law wrong. The court reasserted a 250-year-old rule that the government can't collect information using general warrants. Intelligence agencies were trying to use these untargeted warrants to spy on hundreds, thousands, or even millions of people without specifically naming or identifying them. They sought carte blanche to spy, or in this case, to engage in certain forms of property interference, including hacking. The High Court's ruling was a significant updating of this ancient precedent for our high-tech world. Not satisfied with only the ability to hack us, the UK government also claimed the power to gather all of our communications data and personal data from communications providers, which could include telephone and mobile phone companies, internet service providers, and many others. The nature of these bulk powers, which were revealed as a result of the various government inquiries that were prompted by the Snowden disclosures, was that, again, millions of people who the intelligence agencies have no reasons to suspect of any wrongdoing would have their data collected and held. We challenged this bulk surveillance in the IPT, which this time found that the UK had broken the law by engaging in this bulk collection secretly and without sufficient oversight. But due to avowals in 2015 and hastily produced handling arrangements, the IPT refused to condemn the continuing collection of bulk communications data and bulk personal data sets. That case is still ongoing due to failures of the UK government to be forthcoming about its oversight of these powers and compliance with safeguards. In another twist, in 2020, in assessing the UK's bulk collection of communications data, the European Court of Justice held that general and indiscriminate collection of that data from service providers is against EU law. Applying that decision, the IPT found the UK's historic bulk communications data collection was incompatible with EU law. This set another strong precedent, which is now being used by Liberty in its challenge to the bulk powers in the Investigatory Powers Act. 10 years from Snowden, the impact of his revelations and their aftermath are still being felt in ongoing litigation, as well as improved transparency, oversight, and safeguards. We did not accomplish all we wanted to. The UK intelligence agencies can still hack and engage in bulk surveillance. But now we know what they're doing and are further empowered to watch the watchers.
Hello, my name is Meg Goulding and I'm a lawyer at Liberty. After Edward Snowden revealed in 2013 that the US and UK intelligence agencies were spying on their populations, the UK government responded to the outrage by shockingly creating a new law that allowed and expanded the practice of mass surveillance, the Investigatory Powers Act 2016. Now, this law allows state agencies to spy on anyone, whether or not we're suspected of any wrongdoing. It lets them hack everyone's devices and intercept everyone's calls, emails, texts, and all other electronic communications en masse. And it forces companies to store and hand over records of our emails, calls, texts, and even internet history. The public donated almost £50,000 so Liberty could immediately challenge this law. And we argued that spying on everyone can never be done in a way that respects people's right to privacy. It's always unlawful. Even if it was acceptable, we said the safeguards in the Act are insufficient to protect our rights. But during our case, a separate European judgment said mass spying could be lawful with sufficient safeguards. So we pivoted and focused solely on our argument that the safeguards in the Act aren't worth the paper that they're written on. And we've had some big wins. In 2018, we won our argument that state agencies should only be able to access our communications data to investigate crime if the crime is serious and they have independent authorization to do so. So the Act was rewritten, and the Office for Data Communications Authorizations was created to approve requests, but only for the police. So in 2022, we then won on our argument intelligence agencies like MI5 should also need independent authorization before accessing our communications data when investigating serious crime. So the Act was rewritten once again. But the safeguards still aren't good enough to protect the general population, but especially lawyers and their clients and journalists and their sources. And we know the safeguards aren't even being followed, as in a separate Liberty and Privacy International case, the Investigatory Powers Tribunal ruled MI5 has been ignoring safeguards for many years. So in May 2023, we asked the Court of Appeal to declare the Act unlawful. And before the hearing, the government admitted protections for journalists are still insufficient and the Act needs to be rewritten once again. Now we wait to see what the court says about the lawfulness of the Act in general.